Hi, ladies and gentlemen. Welcome back to our live show, the SAP IP Business Talks. This week, the second time, we have a very tight schedule, and I have the honor that Robert Plotkin and Bastian Best together are in our show today, and that was the only chance that we do it today. And we have now a very challenging situation because Bastian is in Singapore, I'm in Germany, and Robert is in New Jersey on the East Coast of the United States. So that is really challenging. And Bastian has 10 p.m. We have here Central European time 3 p.m. and Robert is 9 a.m. So that was the chance to do that. And we talk about patenting AI. And that is obviously a very hot topic right now. And I'm very happy that we have these two guys here with us. And both guys already had a lot of things to say about this topic. And we have them already on the platform. So we have podcast with content from Robert. We have a podcast with content from Bastian. Bastian is also a lecturer at the SAP IP Business Academy. So here on the blog of the IP Business Academy, you have a portrait about his lectureship. He also talks about the client relationship awareness, about the question, how do we today interact with clients and how to make business development online. And we have also the book review from Robert on the blog. So that means both guys are already with us. And now I'm very happy to have them here in the show. Just one comment, we are live on LinkedIn. That means you can write down comments or any questions, and we are happy. I'm happy to bring that here in the discussion. Bastian, thank you very much for joining us. Tell us, first of all, how did you came into that field of IP?
Oh, it says I'm muted.
Now we can hear you.
Oh, okay. Sorry. So, thanks for having me, first of all. So, it's great to have you, also Robert, here on the line simultaneously and having the opportunity to talk about this exciting topic with you. How did I come into contact with AI patents? Well, I mean, so actually, I'm a computer nerd. I've been a computer guy all my life, basically. And then at some point in time, became a patent attorney. And actually, so when I started my career, so in one of the big patent law firms in Germany, my boss, my supervisor, patent attorney, he was a physicist, but he had this client, this big client, a software manufacturer, right? And so my boss was looking for a new trainee to work on those software cases, and that was me then. So I kind of learned software patents by doing it, right? Because at the time it was, so this was 17 years ago. Yeah, we didn't know so exactly how should we deal with those new kinds of virtual inventions. Those weren't the typical mechanical components or things like that, but some kind of new database scheme and things like that. So I basically learned this by doing more or less. And then grew into the topic of software patents.
Learning by doing.
Learning by doing over the years, exactly.
Great,
And I mean,
great,
then, a couple of years ago, maybe I would say 5-6 years ago, the AI hype started to enter the patent scene. Also, of course, patents always are a bit behind, I would say, with the general technology developments. So clients started to notice that the inventors suddenly were not building prototypes anymore so much, but we're talking about neural networks and I don't know, training these things in the cloud and digital twins and things like that. And so that's when I came in contact with AI. inventions. And yeah, haven't regretted it ever since. It's an extremely exciting topic because it's constantly in flux, right? The legal frameworks are constantly developing, and so it's really exciting. And I'm
Well,
also
that's why we are here.
that's why we're here, exactly. And my other touch point with AI, so my passion is not only patenting AI when my clients have great AI related innovations, but the other touch point is how AI will or is already shaping or reshaping our profession as patent attorneys. And I'm always playing around with all sorts of AI tools for patent drafting. So that's my other touch point, but that's not the topic today. But AI everywhere.
Yes. But I make advertisement for you. So you run. We have a summary of one of your workshops on the blog, and pretty big fans are also around. And I see already the first comments, so that's good. Okay, Robert, thank you very much to be here and to discuss with us the US perspective. So how did you came into that field? I guess 25 years ago or even longer.
Yeah, I mean, if I really go back, just like Bastian, I'm a computer nerd. I started programming first in BASIC on a TRS-80 back in the early 1980s. I was about 10 years old, and I remember in high school, I did a project where I wrote some software that learned on its own how to play tic-tac-toe. It's kind of a very early form of machine learning. Developed weights, for winning and losing moves, based back actually on a project that was done in the 60s on physical tic-tac-toe boxes that contained beads that represented the weights for different moves on different boards. So that was my first exposure to AI. Then I became a patent attorney back in the mid to late 90s, focusing on software. Was really fascinated by the impact of AI even back then. I ended up writing a book about computer automated inventing back in 2009 called The Genie in the Machine. I use this metaphor of the computer as a genie that you could give a wish to back at that to help create designs for new inventions, create software, etc. At that time, there was no AI that you could instruct in natural language to give it wishes. You had to use much more technical types of instructions, but it did exist. And even back then in the 90s, people were just starting to get patents on inventions that had been created with the assistance of AI. But the topic didn't get a whole lot of attention until, of course, a few years ago, once ChatGPT was launched and the field really, really took off. And it's been very exciting to see that all happen, be part of it. And to most of what I do is to represent companies, mostly small growing companies who are developing AI and other software technology and helping them to obtain.
I mean, at least we have now three different ways how AI has an interplay with patents. So the first is the patenting of the AI, let's say, solution or application. Then we have the fact that AI itself can invent, and I hope nobody is in doubt about that anymore out there that this happens. We have we found new protein structures and new materials and whatever. So I think there shouldn't be any doubt that this can work very well. And third, we have the AI, which is used as a tool to draft patents. So for today here, we want to focus on the patenting of AI and AI solutions. And maybe we have to differentiate that also a little bit. But first of all, I would like to start, and that was the idea when I were in contact with you, Robert, and then with you, Bastian, that we said we should use the time here on air to discuss a little bit the difference or the alignments between the European perspective. And so even when you are in Singapore, Bastian, you are a European patent attorney and have European clients and work in European patent law. And I would like to compare that, Robert, with the US perspective. So I simply throw it now in the discussion. So is there an alignment or are there differences? And how critical are these differences, which we should be aware when we want to file, for example, in both jurisdictions?
I mean, I'll speak from the US perspective. I'll let Bastian say, how Europe works and whether it's similar to or different. In a certain respect, although the US law doesn't really use the terms technical effect or technical contribution, in practice, the way the law is working in the US now is very much in line with that, increasingly over the years. We use terms like a practical application. But the U.S. Patent Office very much is looking for some sort of a technical feature within claims in order to be patentable, certainly in order to satisfy the patentable subject matter or patent eligibility requirement under Section 101. And the U.S. Patent Office has been putting out a series of guidelines over the last few years for patent eligibility, which I think have generally been very helpful, with the exception of the update that they gave last summer, which included some examples specifically on AI, which I think unfortunately muddied the waters a bit. And I've certainly been seeing
really helpful.
Yeah, we can get into it later, but I'll say there was an example that they gave, which I think is inconsistent with a previous example that relates specifically to AI-related inventions. But other than that, I'm always telling people, if you have an invention that works in the guts of AI, like training, a new method for training a model, that's something that's going to squarely be patent eligible in the US. If you have an application, something that the end user uses, you really need to make sure that it has some algorithm or feature within it that is technical in some way. If what you're focused on is the benefit to the user, like saving the user time, that's not necessarily going to be enough. The claims need to point out the mechanism by which that is done technically within the computer. I'll let Bastian go from there.
I mean, that's close to the understanding at the European office, right? Bastian.
That's what I wanted to say exactly. So happy to hear, Robert, that you said, I don't know, didn't count, but you said technical at least maybe 6 times or so. So that's great to hear that also the USPTO has this idea of something technical being the prerequisite for patents, for AI patents. Nevertheless, I think there are, I mean, empirically speaking, right, when I look at the cases I'm dealing with, right, I think empirically speaking, there are differences. I mean, there can be no doubt, right? Because, I mean, at the moment, for the same AI patent, so if you file the same AI invention in both jurisdictions, I think it's quite common that both patents will have a different or can have a different fate, right? I think on the one hand, this is just normal because, I mean, AI is a brand new field for the patent system. So the patent systems around the world just have to find their way how to deal with that, right? But at least in my experience, right now, at least, it's more common that when you file the same AI patent, in my experience, it's more common that it gets allowed in the US and refused in Europe. And the other way around is less common, I would say. So my impression is that the US is a bit more easy, not easy, but a bit more easy than Europe, maybe. So at least that's my understanding or my impression from the cases I'm dealing with. Nevertheless, I mean, it's good to hear that both jurisdictions apparently have this idea of technicality in some sense. But then again, my impression is that the US understanding of technicality is maybe a bit broader. You were talking about a practical application, right? And if you tell an EPO examiner that you have a practical application, that's not enough for an EPO examiner. So a European examiner will always want to see a really, really hard technical application, in the sense of, something physical going on or computer resources being used more efficiently, something like that. Not only practical in the broader sense. The issue I have a little bit with the European approach these days is that, I mean, it's a bit at odds with on the one hand the sheer number of patent applications being filed, right? Because I mean it's an exploding field, so the applicants clearly want patent protection and they need strong patent protection. And on the other hand, I mean the EPO itself in their marketing, they are acknowledging that AI is one of the most fundamental technologies we have in our lifetime. But then when it comes to patents, sometimes they say, well, it's mostly abstract math. So yeah, it's a difficult situation right now.
One question which Maya Fenster came up with from Israel, so he asked about the development. I mean, maybe not over the last 25 years, but I think it's also relevant that over the last 2 years, we saw the different approaches. Also, Robert, you mentioned that there is a development in the way. Also, Bastian said that of course everybody in the system, in the IP system, has to find a way of modeling through. But you said there is a recommendation, an example in the US from the USPTO, which makes things worse or unclearer, more opaque. So can you tell us what happened there?
Yeah, so the US Patent Office has been putting out a series of different guidelines on patent eligibility specifically. So these don't relate just to AI, largely to software and to pharmaceuticals like drug patents. But they're generally applicable to 35 USC 101, which defines patent eligibility or patentable subject matter in the US. And those have generally, I found, been very useful. They attempt to summarize the case law, which, as we know, the Patent Office technically doesn't create new law. It's only supposed to interpret and apply the existing law. And in addition to distilling the case law down into guidelines that the examiners then use, but because we know that the examiners use them, we as patent applicants can use those guidelines to attempt to draft patent applications that will satisfy the guidelines. And we can also use the guidelines in responding to rejections. So if the guidelines say that an improvement to technology is patent eligible and the claim is rejected, and we think that the claim represents an improvement to technology, we can point to the guidelines and say to the examiner, look, the guidelines say that if this is an improvement to technology, you need to consider it to be patent eligible. So those guidelines are very useful. In addition to the guidelines themselves, or as part of the guidelines, the Patent Office has been putting out examples of claims and then explaining which of those claims they consider to be patent eligible and which are not patent eligible. Many of those claims come from decided court cases. Some of them are hypothetical claims that the Patent Office has just come up with to be illustrative. And in particular, there were some AI-related examples that they put out a couple of years ago, one of which was really helpful, I found, because it related to the training and use of a neural network and essentially said that certain claims that talked about training a network were not too mathematical because they didn't use mathematical terminology. They used terms like training and generating, which are not mathematical type words. I'm summarizing, but essentially, and I often use those, and I found that examiners were relying on those. And then last summer, the Patent Office put out a few more examples, some of which were specifically AI related. And there was an example involving training of a neural network in which the Patent Office said, no, this is not patent eligible because training of a network inherently involves mathematical operations, whatever you call it. So I don't see how to reconcile these two. I think they're inconsistent with each other, but it's interesting that they represent two really different theoretical approaches, which is, do you look at just the language that the claim uses and ask, is this mathematical language like multiplying or calculating? Or do you look beneath the surface of it and ask, does something like training a neural network inherently involve mathematical calculations, regardless of whether you use the word calculation? you know?
Got you.
And this is for many years been an issue. Different courts have come to different conclusions about that, right? Do you look at the surface? Do you look beneath the surface? And I found a lot of examiners relying on this and saying they I think are sometimes interpreting it even further to say that any claim that only involves training a network is not enough to be patent eligible. And I've more recently, this is only since last summer, started pushing this by adding in additional limitations beyond just training, like details of how the training is done, or details about what type of architecture the neural network has, and arguing that that goes beyond just mere mathematical computations. And we're just going to have to see how that plays out. And some of these cases may have to get appealed within the patent office or even in court. We'll see. I'll hope that the patent office issues some updates, but we can't rely on that necessarily. Okay. So the last thing I'll say is, when you ask about the US approach, what I'm finding out is increasingly it's an examiner by examiner approach here in the US. There is so much variation amongst examiners. It almost is like there is different law for different examiners in the US. That is not a good situation, but it is what it is. I mean, the law should be the law, and the patent office should have a unified approach to the law, but there is so much leeway that's given by the court cases and even by the patent office's own guidelines now, that I'm finding we just have to be prepared to meet with, speak with every examiner, work with them individually. And that increasingly means writing patent applications that are thorough, have extensive specifications that provide a variety of different alternatives to give us different options for amending claims and making arguments when it comes to prosecution later, because we don't know what we're going to encounter.
Yeah. I mean, that was exactly what I wanted to ask, because Renat Kozadayev asked that in the chat, that he has the feeling that in the US, it is really depending on there is a certain inconsistency in the granting procedure or examination procedure between the different examiners. And he has the feeling that at the EPO that is more consistent. So I hand over to Bastian. What would you say? Is that also your experience?
Yeah, I can confirm that. I would say that, overall, EPO examiners make quite consistent objections and draw quite consistent conclusions. I mean, of course, in the end, every case is different, and every case has its individual aspects to it, right? But I mean, the legal framework is, as such, is quite stable in Europe, and the short guidelines on specifically on AI, which we have from the European Patent Office, they are applied quite consistently across examiners, I would say. Yeah.
So Markus Riester asked an interesting question, which I can show you that. So he asked, could you comment on the patentability of federated learning? I think that is something what you said, Robert, about is the training now enough or not, and is training per se a technical activity or not?
I'm not familiar with specific patents on federated learning, but I'll step back and just say this is one of the problems with relying too much on specific examples as a guideline, because there is so much variation in how AI works and in how machine learning works. There's so many different ways of training. There's so many different types of machine learning models, and it's all evolving rapidly, that I would hope that the US Patent Office could understand that and not get too fixated on specific examples and then attempting to generalize them to different patent claims where they're not really applicable. And I think it's true generally outside of patents, just we see culturally, people see the widespread models like large language models based on based on transformers and neural networks, and sort of assume that that's all there is. And that's a kind of generalization from what's common that is dangerous, because there's lots of other types of models out there. There's lots of other types of training, and it's evolving all the time. And if you then reject claims that are based on a technology that's different from what's in an example or what you're familiar with, you're really doing a disservice to the patent applicants in that case, based on an overgeneralization.
Yeah, of course. I mean, for pictures, we have diffusion models and so on. I mean, these large language models is just one aspect of it, of course. Bastian, please.
I think the federated learning is actually a good example of to look at briefly maybe how the EPO really thinks about these kinds of AI aspects. If we have a minute for that, because
Yeah.
I mean, as you said, Robert, right? You said, well, are we looking in the US? Are we looking more at the words, right? How they are used, or are we looking beneath? And at the European Patent Office, the examiners are clearly looking beneath the linguistics, right? They are always asking, what is it? What does it mean? What does it do? Right? What's the purpose? And maybe federated learning is a good example here, because I mean, what is federated learning? I mean, if we understand it as, training a neural network, I don't know, based on, multiple local data sets, right? On distributed nodes in a network, maybe, so that every node can do a part of the training, and you don't have to explicitly, exchange all the training data or collect it at one place. If that's federated learning, then something like that would be pretty technical for the EPO, I would say, because you could arguably say that, well, if you have these distributed system, you might have, performance improvements. Maybe it's faster, right? Because you can have a whole cluster training the whole thing. Or maybe also security aspects involved here. So if you don't have to, if each node has its own private training data, right, and the other nodes do not have to know what the other nodes know, there's maybe some security aspects involved in certain use cases. So these are things that are accepted as quite technical, I would say, at the European Patent Office. And so that would be a nice example, maybe. And then the point is always at the European Patent Office, once you've mastered this, once you've overcome this technical effect hurdle, that's only the first hurdle, so to say, and then these features then enter the last hurdle of obviousness, or inventive step, as we call it in Europe. So this whole technicality discussion is always just a precursor in our thinking for the final hurdle, then, so to say. And then you have to be the first, basically, right?
Of course, it should be new. Just one other aspect, and I think that's also a very good question from Benito. He said, "Are there common challenges for patenting AI algorithms and models? Is there something where you would say that doesn't work anyhow, or that is a route which typically works?"
You mean something that's generally successful in obtaining patent protection?
Yeah. So how to frame it? Yeah. So when I'm, so to speak, sitting in front of an AI solution and say, how do I have to describe that I'm on a good path to make a first evaluation for myself, whether this is technical when we use the European terminology, and Bastian gave some examples. For example, where the data lies, and whether in that origin or location lies a certain advantage, for example, efficiency or timing or data security. So that I would say technical aspects of it, that the model runs more efficient, that I can create new and astonishing results out of the model because of the application of that technical features. So something like that, I would say, can be seen as a common ground?
Yeah, I mean, one thing I often am pushing clients on, which is true for all types of technologies, but I think it's probably even more true for AI because AI is so generally applicable and so powerful and improving all the time. It's important to really push yourselves, or for us as patent attorneys, push the client. What is it about what you've invented that wasn't possible to do using off-the-shelf AI? Why couldn't you just take something off the shelf and in some easy or trivial way adapt it with a prompt or something else to achieve the solution? And they generally have an answer, but if you don't explicitly ask that question, you may not write the patent application in a way that provides sufficient information about what we keep coming back to: the technical contribution, the technical problem you had to solve, the challenge you had to overcome to create a new solution that couldn't be created with just off-the-shelf components or in some trivial way. And the reason I say that that's even more important to do for AI is that AI is so powerful, you can do so much with it off the shelf. So to satisfy, now we're moving more towards non-obviousness, right? To satisfy that other requirement of inventive step or non-obviousness or going beyond the state of the art, you really have to push yourself to make the case for why this invention satisfies that hurdle.
Wonderful. Yeah. Bastian, any recommendation from your side?
How to frame an invention, an AI invention, so that it becomes, or that it maximizes the patentability chances. Yeah, I mean, in Europe, you have to focus on hard technical effects and hard technical advantages. So you are on the safe side, or you have good chances if you can convincingly argue that you have your AI has an effect in terms of less compute being used, less network bandwidth being necessary, less memory requirements, things like that. If you can, but you have to convince the patent examiner that the way your AI solution is designed really directly impacts these hard technical impacts. Or if you are lucky, so to say, if the application domain is inherently technical already. So if the inventors are, I don't know, from a packaging machine producer, and if they invented an improved AI solution that has a better predictive maintenance for their packaging machine, right? You are inherently in a technical industrial setting, and then the AI just is a technical tool like everything else. So then you don't have any problem with this technicality discussion. But that depends really on the industry of the client, right? And you can only influence that so much.
Yeah, got you. Maya Fenster has again a very good question, and I like that really one. So can you highlight some situations where you can definitely get a patent or have a very good chance to get a patent, but you cannot get good protection in terms of, for example, it's easy to design around, or I would like to add, or the detectability of infringement is close to nil, which is especially in software questions. Can that be the case? So, Robert, can you tell us something like that?
Yeah, I mean, the second point you raised, I think, is the easier one to answer, which is I often would say advise either potential new clients or existing clients that it's best to keep what they're doing as a trade secret. We keep talking about training as one example. You know, that's a really tough case for deciding whether to patent, because very often you won't know how your competitors are doing their training. So you might have something that is highly patentable, technical effect, non-obvious, really great innovation, but it's very hard to detect infringement.
Don't talk about it.
Yeah, you know, it's very much like traditionally for microprocessors, right? A lot of the big microprocessor companies, Intel and so forth, have often kept some of their best innovations as trade secrets because it's hard to detect infringement. There are other reasons sometimes to patent, even when you have a hard time detecting infringement, but that you have to have your eyes open about making that kind of decision. When it comes to designing around, I always tell people it's really hard to know in advance whether not always, but often hard to know in advance whether it's going to be easy to design around something, because you can have an innovation which at this moment is very broad. It's the only way to solve the problem. Anyone else who wants to achieve the same result has to use your invention, but who's to say that tomorrow someone won't come up with some orthogonal approach that solves the same problem in a different way? That's the nature of innovation. I mean, you can't know whether someone's going to invent something else. So this is not going to sound like a satisfying answer. But I would say when I'm talking with clients, the best we can do is say, based on what we know about the state of technology and the industry now, does this seem like something that sort of covers the field enough, and that you don't know of any other type of approach that could achieve the same result, that if you think a competitor wanted to implement this type of feature, there's no other known way to do it? Well, then we'll say the chances of designing around are low, but we can never say zero.
Yeah, and it's not a bug, it's a feature of the innovation system, so to speak.
Right.
Bastian, what would you say about that?
I mean, my of course, clients are asked that all the time, especially startups, right? When they come to me for a first consultation, and they are wondering whether it makes sense to file patents for their AI innovations, right? The question is always, does that make sense? Because we've heard that software patents are not detectable anyway, and you cannot enforce them. So yeah, I mean, in the end, it's a spectrum, right? And always, I think you always have to balance. Also, detectability is just one factor, right? In evaluating an invention, and I mean, on the other hand, if the business case is big enough, right? If the market opportunity is big enough, of course, it makes sense to file patents, although the resulting patent may be quite difficult to detect, right? If only the business case is there, then it still makes sense. And I mean, in practice, I really haven't seen a patent which is 100% not detectable. I mean, even if of course, when you are writing it and when you have a good patent attorney, the practice is, of course, to focus on, the interfaces and try to get it as detectable as possible. But then still, if you have to narrow it down during the prosecution, maybe so that it gets a little bit more difficult to detect, you still have a bunch of measures, like in the end, if the business case is big enough, you can have like inspection proceedings and things like that to find out what your competitors are doing if you have a reasoned suspicion that they are infringing. And then on the other hand, also on a case-by-case basis, I mean, many of my clients, they are actively also publishing their solutions in parallel to patenting, right? They are publishing in research magazines and things like that. So also there you can find clues sometimes. So it's a spectrum in the end, and detectability should not be the only factor, I would say.
Yeah, got you. I would like to proceed a little bit to a different topic, which we have not that much time anymore, but we had, according to with Davos, and we had Malte Kölner is right now giving lectures to my students in Strasbourg, and we had a discussion about inventorship, and I would say that will become, even maybe it is already, but it will become the bigger issue, okay? Because it affects each and every technology. And I can only cite a guy who said only people who have never worked with AI are not afraid of AI. And I like that, because it really, I mean, when you have seen the inventive contribution of AI already today, it is amazing. So this discussion of inventorship has to be made. And at the moment, we have this situation that the officers say an AI cannot be an inventor. So yes, maybe. I mean, that's the solution for the moment. But de facto, AI is inventing heavily. So what would you say? So what might be a direction? And especially in the US, I mean, in Europe, I have heard that you say, okay, come on, I have prompted it, so I am the inventor. But in the US, we have this true inventor discussion. So what would you say? In which direction should we proceed? What makes sense, Robert, please?
Yeah, so I agree with you that I've certainly, every time I work with some new AI technology that really excites me and motivates me, I have equal amount of fear, because you've just experienced both sides of the implications of whatever this newest development is. And I think you're right. If you don't feel both of those, I don't think you're getting it. You're probably not really getting it. So on the inventorship side, I understand why people go there. Even when I wrote the book, I addressed this. You know, it's the first thing that comes to mind, I think, when people encounter AI that can start developing or generating information, whether you call it inventing or not. I think that people have both, on the one hand, jumped the gun on concluding that AI can truly invent, or maybe should be named as an inventor. But I absolutely agree with you as well. It's coming, you know, it's certainly coming. Now, it's coming in the sense of AI being able to do work that traditionally we would label as inventing. But I actually think from a policy perspective, it still doesn't make any sense to name an AI system as an inventor. I'll just speak from the US policy. The policy, we're pragmatists here, right? I mean, so the policy reason for naming someone as an inventor is to prospectively motivate that person to do two things: to put their time and effort into inventive activity, and then to disclose their inventions to the public rather than keep it secret. So when I'm an inventor and I wake up in the morning and I decide whether I should go for a run or sit down at the desk and invent, and I think, oh, I could get a patent and that could get me some profit, I decide to put my time into inventing. And then when I invent and I decide, should I keep this secret and license it in secret, or should I disclose it to the public? The fact that disclosing to the public through a patent will give me some more profit motivates me to disclose it to the public. An AI system is not influenced by those motivations. It doesn't decide whether to invent or not based on whether it's going to get a patent. So I actually think it's a red herring to decide whether to label an AI system as inventor. But I do think it raises bigger questions in general about if we really reach a point in which there are widespread AI systems that can essentially replace human inventors. I think we have to go back to first principles about what type of intellectual property systems we have and who should be reaping the rewards of innovation, and what are the costs and benefits of providing IP protection.
Okay, thank you, Robert. We have only 1 minute left.
Yeah.
Bastian, please, short answer.
Short answer. I'm basically on the same page as Robert. I mean, at the core of the Davos question, I mean, it's basically the question, what happens if an invention was made exclusively by an AI and there is no human in the loop who could be named as the inventor, right? Yeah. And I don't have a single client who had this case. So I think it's an interesting question, but more of an academic one. So in my practice, every client has some human involved in the invention process, and that's then the inventor.
Okay. So first of all, thank you very much to you both. I have a final remark. We have decided at SAPI that it makes sense to offer a university certificate from a European perspective, of course, for patenting AI. That will happen the first time in 1st and 2nd April this year. and you are invited to join us, the audience. It will be hybrid, so we want to have it as open as possible and to make things clear under the European situation and under European law. And I hope that helps a little bit also to motivate more people filing their patents on the one hand, also industry representatives to come to understand better how it works and to bring at the end the ideas to our patent attorneys. So thank you very much to you both. Bastian, thank you for staying up so late, so now you can enjoy something cool to drink. Robert, thank you to you for the US perspective. Very, very good. I like that pretty much, and I hope I have the chance to meet you again in person one time. So at the moment we are on different continents, and it is absolutely fascinating that this can happen, what we did today. So enjoy your days, your night. Bye-bye, and thank you to the audience. And Robert, Bastian, it would be great if you could spend some time also on LinkedIn and to answer the questions which are, so the audience was quite active, let's say. So thank you very much. Bye-bye.
Great.
Do that. Thanks for having me. Bye-bye.
Thank you. Bye.